Good morning, Mr. Mandela.
Thank you, Madam Chief Justice. Good morning, members of the court. May it please the court, Robert Mandillo, on behalf of the appellant Kevin Furtado. This is an employment law case in which the employer, the town of Plymouth, ordered one of its employees, Kevin Furtado, to take a lie detector exam after all criminal law enforcement investigations into his alleged criminal activity.
Well, that depends on what you mean by a criminal investigation.
I think that is correct, Your Honor.
So what is a criminal investigation?
A criminal investigation is an investigation into a potential or an alleged crime in which the government, through the police department or the district attorney's office or the attorney general's office, is seeking to find if someone has committed a crime and whether they're going to charge that person or persons with a crime.
That's
Do you
pretty
have to be
elaborate.
able to charge?
Yeah.
Do you have to be able to file a criminal charge?
Well, I think that you're investigating whether you would be, in fact, filing a criminal charge or not. It's an investigation into whether or not you are going to charge someone with a crime.
What if we say it's an investigation into whether a crime was committed?
Well, if it's an ongoing investigation,
And just an investigation into whether a crime has been committed,
looking to the possibility.
without indicating what the next step is.
Well, I would submit, Your Honor, with all due respect, that I would agree with that definition, but the definition of a criminal investigation, I think, the common understanding of that would be that they're looking into whether a crime has been committed and whether or not to file charges against a person for a crime.
Mr.
Doesn't
Mandela,
this
it's the...
mean
I'm sorry, Justice Gorsuch.
Doesn't this mean, though, if we accept your view of this, that in any time when there is an allegation that one employee, it isn't a multiple potential criminal defendant situation, but one person, and that person is a municipal employee, and in order to be able to ask any questions has to be granted transactional immunity, that there can never be any administrative use of a lie detector test. That's what you're saying.
Well, I think I'm saying that, Your Honor, because for two reasons. Number one, by statute, the legislature, while generally declaring that any use of a lie detector statute is a crime if an employer uses it, says that it can be used by law enforcement agencies in a criminal investigation. Whether the results of such a test could be used subsequently in a administrative proceeding is a question that I understand that this court has not decided.
Well, what if
That's
there are
the
other
question here.
uncharged people or unexonerated people? The word is slipping my mind. They didn't get the protection that Furtado got in this case. If there were other people involved, are you saying that they could not do a lie detector test on Furtado because even if there are other people who could be exposed to a criminal charge?
If there were other people being investigated at the time that Officer Furtado was asked to take a lie detector test, and he had been granted immunity, which he had, then he would have had to submit to the lie detector test because there would have been an ongoing criminal investigation of others.
So in that situation, you could have Officer Furtado taking a lie detector test, and let's say whatever the result is one that, and they ask questions in the lie detector test about his own conduct, not just these other unprotected people.
Correct.
And the result of that is contrary to what he was saying, that in other words, they find that he was not being truthful. And so there is disciplinary action. That would be okay, but if he's the only person, you can't do that.
Well, Your Honor, I don't think I said that that would be okay. I think what I said is that I am not aware of any case in the Commonwealth where the lie detector test would be competent evidence to form any judgment in a civil matter. This Court has made clear that in criminal cases they cannot be admitted by anyone. And so I'm unaware of whether of any cases saying that it could be used against him. In this case, he did take the lie detector test,
Right.
and the chief had him back on.
I appreciate
so he
that.
wasn't disciplined.
Right.
Had the chief decided on the results of the lie detector test to discipline him, well, that would present another issue.
That's what I'm asking.
That has not been decided by this court. And the appeals court decision referenced that. The case did not present that issue. And I don't think it presents an issue to this court as to whether the results can be used in an administrative proceeding against Officer Furtado or some other officer.
How do you
Mandela, you-
respond to the catch-22 situation that the appeals court posited that your position presents?
There is no catch-22. That is my response. The statute carves out a limited, clear exception when an employer can ask an employee, can force an employee to take a lie detector test. And it's our position that that exception was not met. Now, if the appeals court decision says, well, the chief in the town were denied an opportunity to subject Officer Furtado to a lie detector test, well, their remedy is with the legislature. I don't
But
think
in any case, Mr. Mandela, didn't you start off by saying this is an employment case?
Correct.
Right. So it just so happens that the employer here happens to be a law enforcement agency. I'm using that term within the statute. But essentially, as I understand your position, it is as follows. An employer may be working with law enforcement agencies, a non-law enforcement agency, ABC company. There's some criminal activity suspected. The employer wants to subject all of its employees or some of its employees to lie detector tests. There's a claim that the local law enforcement or the local police department may be acting as an agent, whatever it is, but the employer says, I want you all to take a lie detector test. The employee says, refuse to do that, I'm not required to do it, and the employer says, yes, you are, because I'm working hand in glove or together with, the police department. But if that's not going on, if there's no criminal investigation, then the employer, cannot force you to take the test, correct? That's your position.
That is my position. If I understood you wanted to say a private law enforcement agency, so to speak?
No,
like the security-
just any law enforcement agency.
Any law enforcement agency. Well, if there is a investigating the possibility of a crime, a criminal
Correct.
investigation, yes, I think the employer can clearly say to the employees, we're working with the Boston police. They're investigating a robbery here at the bank.
And I want you to take a lie detector test.
No problem with that. There's no problem with that. And as a matter of fact, it would appear that this statute works, because I haven't seen any reported cases where private employers are unlawfully ordering their employees to submit to a lie detector test.
It seems to me that one way of interpreting the statute is to say there may be lots of reasons why the Boston Police Department, in your hypothetical, could not force the employees to take lie detector tests, right? They're the government, and they have no reasonable basis to order these people to take lie detector tests. But the employer could. The employer could. And essentially what the legislature was saying is when an entity is acting as an employer, it is permitted to force its employees to take a lie detector test if there is some ongoing criminal investigation.
I
or
agree.
some
But only if they're administered by law enforcement.
Exactly.
The employer
Yes.
can't say, I want you to go take some private tests.
No,
because
that's fine.
Correct. I agree, Your Honor.
No, but
Right.
but
Law enforcement doing the
sure,
public test.
but it's
Law
easier for
enforcement
the
or-
employer to order, in these circumstances, it's easier for the employer to order 100 bank employees to take a lie detector test to be administered by the Boston Police Department.
Correct.
Than it is for the Boston Police Department to get 100 employees to take a lie detector test.
Correct.
Correct?
I
And so the
agree.
legislature may have said, when it's an ongoing criminal investigation, my reading of the statute is that it was not dealing with the unusual circumstance when the employer happened to be a law enforcement agency. That's not what the legislature had in mind, at least as I read the statute. Correct?
That may be so, Your Honor, and clearly what makes this case easier for the lie detector test to take place is that the town, the employer, has lie detector apparatus, if you will, in people who can do a lie detector test. So it's much easier for a public employer, such as the town, to in effect force someone, an employee, to submit to a lie detector test because they've got the stuff. They've got the machines, they've got the people who can do it.
It's not just that. They happen to be a law enforcement agency, but your argument is they're not a law enforcement agency within the meaning of the statute at that point. They are an employer at that point, correct?
Yes, that is my position, Your Honor, that in the circumstances of this case, the law enforcement agency was not acting as a law enforcement agency per se, but as an employer. And as the employer, which happened to have access to the means to conduct a lie detector test, then ordered its employee to take a lie detector test after a criminal investigation had concluded and after Officer Furtado had been exonerated.
I understand your argument, but let's take this one step back. There's an allegation made. If the allegation is true against a police officer, if the allegation is true, it's false.
Correct.
So the chief of police starts an investigation into that allegation and basically instructs the officer that they're going to have to take a polygraph test because there's an investigation of a crime. Right? Now, other legal provisions basically permit the officer to refuse to take that test or refuse to answer questions, right?
Correct.
Unless they're given immunity.
Correct.
So this person is then given immunity. You say it's over, no polygraph at that point, because there could be no prosecution. So no even though it's still an investigation of a crime, there could be no polygraph forced because there could be no prosecution.
When in the case such as this, where there's only one potential defendant, that's correct. If there were other potential defendants, then the employee could be required to submit to the lie detector test after transactional immunity.
Doesn't that put a police department in an unbelievably more tenuous position than a private employer? Certainly if a private employer reports to the police that one of their employees has been accused of the same crime, and the police come in and say, okay, we're going to do a polygraph, and the private employer tells its employee, this is a criminal investigation, the law enforcement's going to do a polygraph, you must take this or be discharged. Certainly the person would have to take it or be discharged.
Correct.
But
Well,
because
he may-
it's the police officer,
Well, he may or may not have
do
to.
that.
Well, the police officer is entitled to privileges against self-incrimination, and in a case where it's only one police officer who is the subject of the criminal investigation, yes, that's right. He could not be compelled to give a lie detector test against himself when there is no ongoing criminal investigation and he is the only potential subject.
Mr. Mandela, I don't understand, though. If you think of it doesn't put anybody in a worse situation. In the private employer situation with the one private employee,
Right.
The employee may say, I'm not going to take a lie detector test until I'm granted immunity. Right?
In the private sector, in which case, as I understand the statute, the employer could say, sorry, you're fired.
That's okay.
Right.
But then it's not because it's a police department. You may or may not be able to be fired in the public sector because of, whatever rules have been implemented over time to apply to public sector employees. But you could have similar conditions negotiated by unions in the private sector. You could have a contract that you will never be fired if you assert a constitutional right in the public sector. In other words, they're both treated the same way.
Isn't it a matter not a matter of contract, but the interpretation that this court and other courts have given that would enable a public employee could not be fired for not taking a lie detector test without being given immunity? That's not because it's a contract right. It's because it's a matter of constitutional law.
That's my understanding. It's a matter of constitutional law. Once the employee is given transactional immunity in Massachusetts, the employee
So
has to answer
the
questions
public
in-
employee is in a very different situation than the private employee in that
I think
regard.
so. For the limited purposes, well, certainly for the limited purposes, I think, of the
Might be.
lie detector statute.
Might be. That is to say, in the private sector, there might, the private, I mean, there are lots of private institutions, for example, that decide to adhere to the First Amendment, even though the First Amendment doesn't apply to them as a matter of state law. So that's what I was talking about. There may be contractual provisions where an employee may or may not be fired.
That's correct. That's correct. Those provisions are not at issue here. This is simply a question of the applicability of the statute in a situation where Mr. Officer Furtado had been cleared and there was no potential for any criminal prosecution.
Well, he hadn't been cleared, had he?
Well, he had been investigated by the district attorney's office. He had been investigated by the district attorney and the attorney general's office.
And they declined prosecution.
Excuse me?
And they declined.
They gave him transactional immunity.
Well,
and
first they
parents
declined.
signed off on it.
First, they declined prosecution. The district attorney's office first conducted its own investigation, declined prosecution.
Yes.
And then, in connection with the polygraph, he was given immunity by both the district
Well, the
attorney's
complaining
office.
witnesses,
Correct.
as I understood it, no longer wish to go forward. So what
the-
could the criminal enforcement, law enforcement agencies do?
Well, they properly decided to do
Right,
nothing.
right, but so he
because-
hadn't been cleared, I mean.
Well, I would say cleared in the sense that they didn't keep the case open.
Right.
The parents were offered that. At pages 36 and 37, I believe, of the appendix, the parents make it very clear
They
that
didn't wanna go
what
forward.
happened here was twisted and exaggerated, and Officer Furtado was a victim of a situation here. I see that my time is up. I thank the court.
Thank you, Mr. Mandela. Mr. Keston?
Good morning.
Good morning.
Us trial lawyers love to be up here. Little did I know I deal my favorite musical here and my favorite book, Catch-22. This is a Catch-22.
Is there any legislative history of this particular provision?
Not that I know of.
I mean, have you
Did
looked?
anybody check?
I did not.
Okay.
Isn't the problem here, which the appeals court may have gotten correct, that the term criminal investigation in the statute is a little bit ambiguous? You can have a criminal investigation, which, as far as he's concerned, is finished because the DA decided not to prosecute. But the police department could still want to investigate the crime, potential crime, to see if it occurred.
Correct.
So that is a criminal investigation, and that I understood to be the point of the appeals court opinion, at least at the end when it summed it up.
And it's jurisprudence of this court. I mean, the way this has all grown up in the law enforcement context, so that the police, in the police context, you want to make sure that given the tremendous power that's vested in people who are sworn police officers, that you get to check on them, you get to review them and make sure they don't do anything bad. And there is a catch-22 here in that the private employers, as Chief Justice Marshall was talking about, the private employer who can order an employee to have a polygraph taken by a law enforcement agency can do that. But a law enforcement agency employer cannot.
I thought that the statute said it's unlawful to discharge somebody for exercising their rights. So that unless there's a criminal investigation, it appears under the face of the statute that a private employer cannot fire somebody for not taking a polygraph test.
Well, that's the
That's the first part. That's the first sentence of.
Unless
But-
otherwise authorized.
But what you're saying is if the employer talks to the prosecuting authorities and says, here's the allegation, will you investigate, then there's an investigation and they can insist that the person go. Is that?
It depends what you mean by the investigation. I mean, we're dealing here with a public employer.
No, I know that, but I was just
think
about
of the
your
private
example.
employer. Think of the private employer. Answer this, if you can, Mr. Keston, which I think goes to the heart of Justice Watsford's question. Let's say the ABC company, private, thinks that one of its employees is stealing, and it says to the Boston Police Department, please come in and investigate. And the employer says to the employees, I've asked the police department to come and investigate. The police department has agreed to come in and investigate into potential criminal behavior, and I've ordered I, the manager, have ordered all 100 employees to take a lie detector test. For whatever set of circumstances, before all of the employees have had their lie detector tests administered, the Boston Police officer who's in charge of the investigation calls up the employer and says, look, we've just got too much going on in the city of Boston. We've got too much. We can't devote all of these resources. We can't sit there administering lie detector. So we're backing out of this, quote, criminal investigation. You do what you want to do, but we're not going to do it. And the employer continues to insist that the employee take a lie detector test.
See, but what you're saying there is that they're not backing out of the investigation. We're assuming there's a crime. There has to be a crime. It's a prerequisite.
Money is missing.
So there is a crime. There's a
Yeah,
crime out there.
Maybe the entries were done incorrectly.
But you're saying the Boston police, in your scenario, do not have the resources to do the polygraph. Doesn't mean the investigation's over. It does not mean that they're not going to prosecute if they get an informant, if somebody comes forward to get some other evidence. It's just they don't have the resources to do the polygraph. And what Mr. Mandela says about resources, it has nothing to do with resources why law enforcement does this. It has been the jurisprudence of this court that says, started in Baker, that says if the conduct is criminal, so there is a criminal investigation, before you can compel the officer to take the polygraph, you have to give him immunity, him or her immunity. So it started with Baker, moved on to Baglioni. Baglioni, this court said, you now have to give full transactional immunity, not just use immunity, transactional immunity statewide, before you can order it. That's the catch-22 of what Officer Furtado was suggesting. That is, they'd love to be able to order him to take a polygraph, especially in something like this. There's no question here the conduct is criminal. This is not a situation where they're trying to transform. And this
The alleged conduct is criminal. Yeah, the alleged conduct is criminal.
If it occurred, it would be criminal.
Yes. Yes, the alleged conduct is criminal. So this is not a question where they're trying to transform a routine investigation into something non-criminal by calling it criminal, which is what the straw man that's being put up here. Could not be a more serious allegation. There was no clearance here, not uncommon. This is not that he was clear that there's nothing to this. This was a situation, they're not actually complaining parties. The complaining party was a doctor, physician. And the parents refused to cooperate with the prosecution. They refused to authorize the physician to cooperate. So the district attorney's office felt at that time there's nothing else they could do at that time. The only reason immunity was given, or they officially gave immunity, is at the request of Chief Pomeroy of Plymouth, who said, okay, I'm faced in this situation where we don't have anything definitive, there's a serious charge, and before I let this officer on the streets again, I want to make sure that everything's okay. Followed the jurisprudence of this in other courts and said, this is what I have to do. I have to obtain immunity at the urging of counsel for the union, who said he will not submit to an investigation of this unless you give him full transactional immunity from the AG and from the DA. They did exactly what Officer Furtado wanted. The only reason we're here is because he failed. Had he passed a polygraph, he went back to work, I anticipate there would have been no lawsuit, no anything. What happened was they were then faced with the situation where the polygraph came back untruthful. And then became the question, not addressed by this or any other court, what do you do with that? If that's all you have. And there were efforts made, the investigation continued. There were efforts made to see if
The investigation continued by whom?
the chief. I
The
mean, once
administrative
immunity is given
investigation.
into the criminal conduct. The investigation continued in that, what do we do now? Will the parents, can we develop more evidence? What do we do with just this? And that the decision had to be made, since there's no case addressing it, could action be taken solely the polygraph, given the fact that the parents were still not authorizing anything to go forward. And eventually it was decided there was nothing else that could be done.
Well, now it wouldn't matter if the parents changed their mind because he has immunity.
No, but
I mean,
in
he
terms
can't,
of
I mean, he can't be prosecuted criminally,
not
period.
prosecuted,
Right.
but in
But
terms of what the
administrative.
department would have done.
He can be disciplined, you're saying.
Absolutely.
So did he waive his rights under the statute by agreeing to be subjected to a polygraph test?
Yes. I mean, he says he was coerced. I mean, he was ordered to do it. What they did, what Chief Pomeroy did, is what's done, has been done every time since Baker and since Baglioni. Since 1995, every police chief in this situation obtains transactional immunity and the polygraph is then administered under
Would you-
threat of discipline.
Would
if
you
don't
agree
take it.
with Mr. Manzillo that the, excuse me, that the negative result or of the polygraph in and of itself would not be a grounds for discipline? You'd have to go forward and prove the case. In terms of the disciplinary case is what I
Well,
mean.
that's what they decided in this case, frankly, was since absent a decision from this court, or an appellate court, as to whether in an administrative proceeding it's admissible. I mean, it's a high road to hoe. Myself, asking my advice, I would say if that's all you have with nothing else, no, I wouldn't discipline on it.
We don't have to get into that, do we?
No, we don't. I
The
just-
sole issue here is whether there was a criminal investigation vis-à-vis that exception to the statute.
Correct.
And you and the town takes the position there was, that as I understand it, in effect, okay, the DA did what he did. The police officer had to get immunity so we could give him the polygraph. We want to find out if this crime occurred. It's a criminal
Correct.
investigation being conducted by the police chief in Plymouth. And that's what the appeals court said in so many words.
Correct, and that has been, as I say, the jurisprudence of this court too, that, I mean, you have to give immunity. You have the multiple defendant question, which has been asked here, which has never been addressed by this court on that circumstance, that you have to give transaction immunity one, but there has to be a live defendant. In Baglioni, there were none. In Baglioni, the crime was much less severe. The Baglioni case involved breaking into a locker in the police station, but in Baglioni, the transaction immunity was given to every police officer involved. So likewise, they eliminated.
I mean, suppose they went to the parents, and the parents, which you undoubtedly have, and the parents say, yeah, this happened, but I don't want to traumatize my kid in a trial and all this awful stuff, and that's why I told the DA we don't want to pursue this. So no victim, no prosecution. Crime has happened, hasn't it? Or there's proof that a crime has happened.
Absolutely, and had the parents, had the lie detector, for example, it's a given, the lie detector happens, the parents change their mind, the doctor changes her mind, somebody changes their mind, and now discipline can go forward on the grounds that you're being disciplined because you committed a crime.
Yeah, how did the doctor get into this? He wasn't the father, was he?
It's
The
a
child spoke to the doctor.
third party.
Spoke to the doctor and told
That's
him
what
this happened, so it was like a 51A.
That's how it began.
Mr. Keston, I know you didn't do the statutes of history, but the amicus brief from the Massachusetts Coalition of Police did do an extensive, it seemed to me, assessment of the legislative history. And have you read the brief?
I have.
It seemed to me, make a pretty powerful case that what the legislature is trying to do is to narrow and narrow and narrow the statute, in which case how we interpret criminal investigation, they suggest, means there must be some possibility that there could in fact be some kind of criminal indictment, not just you want to discipline somebody because they might have participated in criminal activity.
Well, not might have. I mean, you have to discipline them because you found that they did. Not beyond a reasonable doubt, not in the criminal context,
No,
but in
no.
the administrative context.
Sure.
So
Well,
but
if immunity were granted to somebody in the private sector, could the police conduct an investigation, a criminal investigation?
I don't think so.
So why can they do it here?
They're the employer. The private sector employer can conduct an investigation into whether or not their employees committed a crime, whether or not their employees prosecuted.
Well, they're not exercising a police function at that point.
Correct. And here, the police department is not exercising the police function. The police department is acting as an employer. See, this is the issue. The police department here happens to be, it's a public employer.
Yeah.
That has an employee that's accused of a serious malfeasance. In this case, a crime. They back away from it, let the DA do their thing. There's a Fifth Amendment right. If the DA prosecutes, if the DA acts, goes forward, they sit back. But once the employer, they happen to be a police department, they are the employer. The DA then says, we don't have enough at this point to go forward, we can't do anything. Now the employer has to decide, what do I do about this employee? What do I do about this conduct that's
But
out there?
is there anything in the legislation that indicates that a criminal investigation in the public employee context is different than a criminal investigation in the private context, a private employer
In the
context?
legislation, no.
Isn't
Well,
the
I have to
investigation an
say,
internal?
what about the 1973 amendment? It's there.
What is the 1973?
At least according to the Massachusetts Coalition, significantly narrowed the broad law enforcement exception that was passed in 1963. I mean,
It changed for the words, "This section shall not apply to lie detector tests administered by law enforcement agencies in the performance of their official duties," to, the section shall not apply to lie detector tests, to what it is now.
As may be
as may be otherwise permitted in
a
criminal
criminal investigation. So it narrowed it. I appreciate your argument, and I think logically your argument makes sense, except that I think you're fighting the legislative history here, which was obviously to protect police officers. And so they keep trying to get the protections
But
greater for the police.
Since the amendment, this court, both in Baker and Baglioni, has said to law enforcement agencies, police departments, that the way to deal with investigating a potential crime by your employee is to give them immunity.
Let me ask you this about Baker, because Baker has sort of, you could interpret it as conflicting language. It says in the paragraph about the argument, well, there wasn't a it quotes something about there was an ongoing criminal investigation, then later it says, but at the end of the day, there's an allegation of a crime involved. Those do seem somewhat, do you need both? I guess that's what I'm saying. Does Baker stand that you need both, an ongoing investigation and a crime involved, or is a crime involved enough?
But you're saying, it's a question of what you mean by investigation. You're saying investigation which has to lead to prosecution.
I'm only asking you what
no,
Baker
it was
itself
ongoing.
meant.
It's the ongoing investigation language that Justice Kaplan uses in Baker against Lawrence. The
Yeah.
facts in that case, as I recall, I'm just looking at it, was that there was an ongoing investigation.
But they had to immunize the officer.
Yes.
And likewise in Baglioni. In Baglioni, which we have relied on for 13 years, says that you have to immunize the officers if the conduct is criminal, then you can order them to you cannot order them to take the lie detector unless you give them pedestrian immunity. This is what this court said to law enforcement. That's exactly what law enforcement has been doing. And if we now change it and say that Baglioni was completely, we don't know why we did that, because once you do that, there's no more investigation. You see that? That's the catch-22 we've been living with, is that we've been listening. By we, I mean law enforcement. I'm no longer in law enforcement myself. But the court has said this is what you have to do. You cannot just use it during the investigation, because of the Fifth Amendment, as a public employer, you have to give them immunity. Okay, we'll do that. Then the court said you have to give them transaction immunity. And the AG, okay, we'll do that. In this case, Officer Furtado says, I won't take the lie detector until you give me transaction immunity. We did that. And then he goes, aha, now that I've gotten it, it's no good. That's the problem that we have.
Now that I've gotten it, you've committed a violation of the statute by
ordering it. No, now that you've given it to me, you can't do it anymore. Right. So they say, take a lie detector, not until I get, pursuant to the jurisprudence, until I get transaction immunity from the AG and the DA, and the minute you give me what I've asked for, now you can't make me.
Because there are no other people involved in this particular case.
Well, he didn't say that at the time.
But that's the unspoken. That's the
They come up
unspoken.
with it. And as I say, in Baglioni, there were no other people.
Because if there had been other people involved, there wouldn't be a problem in this case, right?
Well, I don't know.
Because there'd be an ongoing criminal investigation.
Conceptually, you could say that, yes.
But does the ongoing criminal investigation mean against that person or against anybody else? You then have that issue.
Well, you could change the law to say from now on.
That's not involved in this case.
It's not involved in this case. And again, it wasn't in Baglioni. When we looked at this argument, first raised by the plaintiff, that now we're requiring multiple defendants, only one to be immunized. In Baglioni, that did not happen. Baglioni, everyone involved was immunized. So this court did not state that requirement in 1995, that there had to be an active defendant. And you don't know in this case, I mean, there might have been a co-conspirator in the pool.
Thank you, Mr. Keston. Your time is up.